Good evening and a very warm welcome to one and all. On behalf of IPNet South Region, I welcome you all in today's webinar on the topic Courtrooms Essentials for Insolvency Professionals. We take pleasure to have with us distinguished lead speaker Advocate Bendi Raviteja, and his experience sharing in the field will add huge value to this session. And as you are aware, IPNet is hosting its 36th webinar in a series of webinars organized periodically under the umbrella of IPNet, the National Network for Insolvency Professionals. Now, without taking much time, a warm welcome to all of you. Now, we'll have a brief welcome and overview of the event significance. So this courtroom essentials for insolvency professionals is one of the area where the insolvency professionals practice. We wanted you all to experience, the advocate to share the experience for the benefit of the participants, and that is all the insolvency professionals. And we thank IPNet team and also the founder Ashish Makija sir for taking this initiative. And I request Reshta kindly please play the IPNet video introduction video.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
So IPNet has become a vibrant community for insolvency professionals across India, fostering continuous learning, collaboration, and professional growth. We are committed to supporting IPs through expert-led learning initiatives like webinars and study groups, practical guidance on IBC-related challenges, and a dedicated member portal offering comprehensive resources. For those who are already part of IPNet, we thank you for your support. For others, I encourage you to join this dynamic and ever-evolving network membership. The details are available in the chat. Thank you all for being there. Let's make this session insightful and rewarding. And I request Geeta ma'am to kindly introduce the lead speaker.
Very good evening, all of you. Let me take the privilege of introducing the lead speaker, Mr. Bendi Raviteja. He is a distinguished commercial law expert and a founding partner of Veera Legal LLP, a full-fledged service litigation and advisory firm operating across Hyderabad, New Delhi, Bangalore, and Amaravati. An alumnus of Damodaram Sanjeevaya National Law University, Visakhapatnam. He further pursued the prestigious postgraduate insolvency program at the Indian Institute of Corporate Affairs, under the Ministry of Corporate Affairs, and is eligible to be registered as an insolvency professional under the IBBI. He is also ranked second in the postgraduate diploma in financial services and Legislation from Nalsar University, Hyderabad. Mr. Ravi Teja's practice span across insolvency and commercial litigation, corporate restructuring, banking and regulatory disputes, strategic commercial advisory, arbitration, white collar crimes, startup advisory, and media laws. He has advised and represented clients before NCLT, NCLAT, high courts, commercial courts, and various regulatory bodies. His clientele includes public sector banks, scheduled commercial banks, NBFCs, ARCs, Telangana State Horticultural University, IT and tech startups, and other professionals from finance, media, and technology sectors. At the intersection of policy, finance, and legal practice, he brings a rare blend of strategic insight and litigation precision, making him a sought-after voice in the forums on insolvency and commercial laws, dispute resolution, and financial regulation. Good evening, sir. Over to you.
Yes. Good evening, all. Thank you, Suhasini ma'am. Thank you, Ashish sir, for this opportunity. And I see this as an interaction session so that we can exchange wisdom and our practices. So today's topic, the courtroom essentials for IP. So I think this is a very paramount topic, which is very essential for the practitioners as well as advocates. Because in the IPC ecosystem, what was introduced in 2016, there were 4 pillars that were introduced for the first time in this country. The first is the insolvency professionals, our esteemed colleagues and the fellow professionals. The second one is the regulatory IBBI. The third one is the information utility, which was introduced for the first time in this country. And the fourth one is adjudicating authority. Now, there is a key role played by the insolvency professionals in the ecosystem alongside with the adjudicating authority. Certain duties and responsibilities as well as powers were vested with the resolution professionals, liquidators, writ large the insolvency professionals for conducting the process in accordance with law. At the same time, the law also bestowed certain judiciary discretionary powers with the adjudicating authority to meet the ends of justice. Now, quite often, we find ourselves in the courtroom. Now, because we are a restricted group of insolvency professionals, I only restrict the courtrooms to be NCLTs, NCLATs, and sometimes Supreme Court in a direct appeal. Now, a fundamental question that arises is what would be today's topic, courtroom essentials for the insolvency professionals. Now, to address and to discuss more on this topic, I would like to start with a fundamental question that the fundamental question when we speak of courtcraft or courtroom essentials. What are the conditions to persuade a court or a judge? What, to my mind, there appears 3 such conditions to persuade. Now, one, the court must have a clear idea of what we are asking the court to do. Now, if we may pause here for a moment and see, if we look into the IBC, there are at many stages, the adjudicating authority's interference is mandated. Now, the admission itself starts by an admission order by the adjudicating authority. Thereupon, considering a case to be of a CIRP, thereupon the first provision, maybe the cardinal rule, is that which is bearing the entire procedure or the process is Section 14, moratorium. Now, what happens in an event of contravention of moratorium? Where do I seek redressal of that grievance? Then we find our answers in 60 subsection 5, where the adjudicating authority has a jurisdiction. Now, who would initiate? Very obviously, the resolution professional or the interim resolution professional as on day, or the liquidator as the case may be. Now, when we go there, the first thing that we must persuade the court is that it must have a clear idea of what we are asking the court to do, in which manner that we are trying to invoke its jurisdiction, and in which manner we want to execute its order to fulfill the objectives of the code or certain duties which were bestowed upon the professionals under the code. Now, the second thing would be the court must always be assured that it is within the court's power to do such thing, which we are praying for. The third one is a most important thing. After hearing the reason for doing what we are asking, and sometimes we will have adversaries. For instance, in matters like non-cooperation, where we would file against suspended management, there would be an adversarial litigation. The suspended management would be represented by their counsels. Now, after hearing the reason for doing what we are asking and the reasons for doing other things, what the other respondents, just an example case of suspended management, so in a non-cooperation case, or doing nothing at all, the court must conclude that what we are asking is the best. Then we may, if 1, 2, 3 have the checklist have been complied, then we may say we were successful in persuading the court to seek what we were indulging the court's interference to. One, the court must have a clear idea of what we are asking the court to do. Two, court must be assured that it is within its court's power to do such thing. After hearing the reasons, three, after hearing the reasons for doing what we are asking, the reasons for doing other things or doing nothing at all, the court must come to a conclusion that what we are asking is the best thing. Now, here I would like to emphasize on one aspect, that we must always ask a right question to get a right answer. Unless we do not ask a right question, we do not get a right answer. Now, 60 subsection 5, the cardinal jurisdictional principle, the jurisdictional provision, which invokes the jurisdiction of the interference of the courts to decide a question of fact or a question of law. Now, our question must be correct to get a correct answer so that our objective would be fulfilled. I would here like to just, on a lighter note, I would just point out an anecdote where a person has asked a priest that, can I smoke while praying? The priest would slap. Like, what obnoxious question is that? That can I smoke while praying? This is a no, straight away. Wrong question, wrong answer. The same question, put it other way. Asking a priest that, can I pray while smoking? In return, we would get a philosophical answer saying that, in which activity can't we pray or meditate? You can do so. While reading, you can pray. While driving, you can pray. While playing, you can pray. While smoking also, you can pray. Asking a right question would derive a right answer. Now, the difference in these two questions is very subtle, but very important for us professionals. The first question, when I asked the priest that, can I smoke while praying? His knowledge has come into the picture, saying that the scriptures require an ordainity or a posterity upon a person, and there must be a pious living. This is all the knowledge. Now, a later question when I asked, can I pray while smoking? That became philosophical, where the wisdom has come. Now, we must also always bear in mind, while appearing before the courts, that we must ask the right question, or what would be a wise thing to be done in a situation which is brought before the court for the adjudication. Now, I remember here an interesting case law, very famous, the Keshavananda Bharati's case. What was happening during the hearing, that was the largest bench of Supreme Court deciding a constitutional matter, where there were difference of opinions. Certain judges were going and asking that, where is this basic structure coming from? Where does the Constitution have these words, the basic structure? Show it in writing. Then the lead counsel, Mr. Nani Palkiwala, heard for so long and stood for once and said, and in fact, he shouted and said that not even a lunatic would think of jumping Berlin Wall from west to east. Now, asking a right question or asking the court to give a wise answer for the question that to be adjudicated, we get the right answer. Then we place our burden to the judge, saying that it is upon your wisdom that we rest our case. Then it is the judicial presumption that always the justice prevails. That the courts, we by law have a judicial presumption that the courts know all the laws. We need not emphasis on the laws. But what we need to emphasize is what we are going to discuss. We'll discuss in today's session. Now, the first and foremost thing that we must always bear in mind while invoking the court's jurisdictions or while we are appearing for various reasons. For most of the things in liquidation, we have more reporting. We need to file progress reports, preliminary reports, asset reporting. Even in the CIRP, also we need to file COC constitution as and when the list of creditors would be amended, revised. We need to update the code. Now, these all where our professionals are entitled to appear, and they are freely appearing also, and the judge would be, because they are the same, they are one of the pillars of the ecosystem. The judges would also be interested. Now, especially in our Hyderabad NCLT, the judges emphasis that the professionals come for especially the matters pertaining to the progress reports, because they want to understand the progress, because they feel that what is happening in the liquidation process, so that what can be done or what are the shortfalls that can be avoided. So they want to keep themselves updated on the matters. Now, when we go or invoking such jurisdictions, the first thing that we must bear in our minds is that be sure that the tribunal has a right jurisdiction. The prayer that we are asking, the relief that we are seeking is well within the jurisdiction of the court. That this assurance we must always give. And not only it is an assurance that is given by a counsel representing a professional, it is expected from the professional that such an important or a crucial fact is placed before the tribunal. Now, I will here share my own experience when it comes to the jurisdiction of the tribunals. Now, I think if one of our members, Gonugunta Murli Garu, if he is there, he is the liquidator of one of the case, GS Oils, where it's an interesting case. After initiation of CIRP, the Enforcement Directorate has provisionally attached the assets of the corporate data. Subsequently, the adjudicating authority, PMLA, has confirmed the provisional attachment. Now, the question before us is, what can we do? Then appeal was filed because the liquidator, that time it was already the company, the corporate debtor is already into liquidation. The liquidator do not have per se the locus apart from representing the company if it is a party. The lenders, being a bona fide claimant, they file their appeal before appellate tribunal. Now, after deliberations and discussions with our professionals and the lenders, we have decided to invoke section 60 subsection 5, saying that this is a violation of moratorium, that there cannot be any proceedings, including that of ED or a provisional attachment. We have placed these things on record. We have invoked 60 subsection 5 of the Honorable NCLT, and we have sought for set aside of the provisional attachment as well as the confirmation order of adjudicating authority, being in contravention to section 14. Now, the issue gets complicated. Why I am telling here is, there is another group company, GS Biotech. What happened in that matter is, the attachment was prior to CIRP. Now, when I filed, the bankers wanted me to file both these matters together, so that as a group company, the resolution would be quick. Now, the facts are so different that the earlier case is of a moratorium violation. The later case is not of a moratorium violation, but for a hassle-free process, that for me to freely conduct the CIRP, I'm invoking the jurisdiction, that the attachment order is coming in between. And there is an inconsistency with the provisions of the IBC and ED. So that a non-obstante clause we have, they have. IBC has a non-obstante clause, PMLA has a non-obstante clause. But they later act IBC, so the IBC prevails. This is what we were persuading the court. Now here what we did was the both matters were always listed together, heard together, because the issue is similar. One day I made a distinction very clear that the earlier case is a clear-cut case of moratorium violation, and the later case there is no moratorium violation. But we are invoking the jurisdiction on incidental and ancillary issues relating to the CIRP. Why this distinction is important is because in an earlier case, as earlier we have discussed the three conditions, in the earlier case, it is a good case for the court to invoke its jurisdiction. It is well within their powers to set anything into motion if it is in violation of the provisions, especially that of Section 14. But the later case, there is no violation of moratorium. Throughout our arguments, we have made this very clear that the later case is not a case of moratorium violation. Now, by making sure that the earlier case has the jurisdiction and the later case, the distinction between had fetched me a favorable order in an earlier case. However, in the later case, we had to go down to the judgment of the tribunal saying that there is an appropriate statutory body. Now, why I say this case law is because it is expected from the professional that we disclose facts clearly, that we do not conceal anything. Most of the tribunals are of the opinion that these our professionals are an extended arm. Just like a criminal court's FEC, the police are an extended arm of the court. So our NCLTs are seeing our professionals to be the enforcement agencies of the IBC. Not truly in the enforcement agencies context, nomenclature may differ, but they see us an instrumental in enforcing the provisions of the code. So that's why they are of the opinion that the professionals are an extended arm. There an additional burden comes to us that at all instances, at all cases, that we must disclose facts correctly. We shall not conceal any fact. And if at all there exists any fact contrary to our interest, when I say our interest, mostly it would be the interest of the COC only. We must disclose that very subtly to the court, but we should not commit an error by not disclosing it. That becomes a professional mark for us. Then, why another important aspect that we must be aware of the jurisdiction of the tribunal is one more thing. It is expected out of us. There is another lenient view that the tribunals are taking nowadays when a statutory authority is filing any application. The statutory nowadays, even in my own cases, and even when I sit in NCLT, I would periodically see that the statutory authorities would file to their own whims and fancies the provisions. In CIRP, they would file something like Section 42, an appeal against the decision of liquidator. On the face of it, it is a wrong provision. But being a statutory authority, a government agency, the courts are taking a lenient view. Such kinds of errors by our professionals are not tolerated. Or in fact, I emphasize to avoid such things because it is not expected out of us, and that would leave us in the court with a remark saying that this is what we are expected, which won't be good in all fair manner. Now, another important aspect, it is purely a court craft. This is nothing about the law or anything. It is purely that the presiding officer is also human. Know your audience, whom we are addressing. know more about the presiding judge. When I say know more about the presiding judge, like seeing his previous case histories, is he lenient? Or what is his judicial philosophy? How is he inclined? Is the judge inclined towards precedence? Or is the judge more inclined towards a dynamic action? Or is a judge sometimes we would face some officers who are impatient, and how to handle such an impatience in a courtroom? Or some judges would tolerate our mistakes, genuine mistakes, some would not. Knowing these things, we would learn how to put forth our case for a better and a beneficial result. Now, moving next, this becomes a very subjective thing, that knowing our case. It is expected from us as a professionals, because we are there from the day one of the process begins. Even if we engage some lawyer like us, we require a briefing from the professional, because he is there from day one. I could only assimilate what the professional says, but the professional will always have a first-hand information. That's why I always tell, whenever I appear for any professionals, I request them to accompany me while appearing before the court. One, that it creates a really good impression that the officer, that the professional is prompt and judiciously assisting the court, so that he would be assisting, or she would be assisting the court, and two, they would be assisting the counsel as well. And while we personally are presenting certain cases where there wouldn't be any requirement of a lawyer per se, there would be a simple matter, or there would be a small ticket accounts where the budget would not permit to engage lawyers, and the matter would also be of a lesser concern. Even in such circumstances, we must be thorough with our facts. We must always speak the truth. At no cost we shall conceal anything that is material, and that we in our own wisdom thinks that this becomes a material that would be required for the court to adjudicate. Now, this leaves us with the impression that we always speak truth, that if such a professional is speaking, then there must be some real cause, or there must be a truth underlying it. So we need not go into the facts. Here I remind myself of a situation what Mahatma Gandhi has mentioned in his autobiography, as well as in another books, while during his practicing days in South Africa. When clients used to come, and attorney-client's privilege, that client would tell everything. And even if he tells that he has committed any offense also, once we accept wakalat, we are not entitled to depose. So there is an attorney-client privilege. Gandhi would say that, you whatsoever, I will only speak the truth. His image has been so popular that his reputation preceded him. The judges of the South Africa, the Englishmen, would say that if Gandhi must have spoken on facts, then that must be true. We will not even look into the facts, and we'll straightly go into the question of. I say that even today we can practice that. And many of the lawyers and professionals are practicing that. I see certain professionals, when they speak, the court would not even open the brief or the petition that so-and-so, the learned professional, has spoke has submitted a fact, then it must be true. And the other important thing would be, we shall always have restraint over our speech. We shall never overstate our case. We will make it crisp to the point. Overstating would make the court think that either there must be something which requires an extensive adjudication, or simply we may take away the attention of the judges. The next one would be knowing the cases of adversaries. Especially, there would be a very limited circumstances, but there are definitely such circumstances in the entire process. There would be either in 19.2, a very common application where we would express our representing, when I represent the professionals, we would express our difficulty that we do not have a particular document, or we do not have an audited balance sheet, or we do not have anything which establishes the record of debt so that we can adjudicate the claims, or we can verify the claims for that matter in CIRP. We file an application that so and so document is required. The adversary would come and dump all the documents which are available and say that we have submitted everything. But they would precisely not give what exactly we have sought for. Now, in such cases, we must thoroughly understand what they have deposed or what they have submitted on affidavit in their counters. More importantly, in CUFE transactions, where their submissions become so vital, which will have an impact on the recoverability, on the resolution of the process. That we must thoroughly understand the case of our adversary. And another important aspect would be with the resolution applicants and prospective resolution applicants, where a commercial decision would come. Even still then, an adversary case or an understanding the adversary's point of view or their stand would always fetch us or always put us in a higher pedestal than not at all knowing their case. And when we have started or when we are presenting our case, we must always lead with our strongest argument. The first thing first. Always start with a statement on the main issue before fully stating the facts. Because this would set the premise. Because this would set the stage. This would give an indication to the judges that what they are hearing today. Without saying that would be something like reading an entire article without a heading. We must be baffled unless I go to the end that, oh, what this is the topic of the an article or a paper, or for that matter, a book. We must always lead with our strong argument. First thing first, we must always put our positive case. The starting few minutes should always be our submissions with respect to a positive case that we have. Then, earlier I have only mentioned that we must not conceal anything which is material. Whatever the refuting case or something which is materially adverse to our submissions, we must put it in such a way that it must always come in the middle. And we must always bear in the mind that we will not begin with it, we will not end with it. It must be somewhere in the middle. For the record, we have said it. And we must put our strong case so much that this becomes obfuscated or there shall be no bearing for this thing. But it is put to the knowledge of the court to take an able decision. We must always select our best argument. This is something like we must concentrate our fire. One best argument. And then followed by rest all. We must not be confused, or we must not be distracted in this manner that our best argument is defeated. That it must always precede everything. That the core, that the pith and substance of the issue must always be dealt at the beginning. We must communicate very clearly and concisely. Even submitting too much would overburden the judges, and they may lose interest in deciding the case. Or due to our own judicial clogging of the and backlog cases, they would adjourn the matter. We must always communicate clearly and concisely. And I already said as that we must always start with a statement of the main issue before fully stating the facts. Now, finally, how we will end our case is that we must have a close, finally we must close it powerfully by saying explicitly what we think the court should do in this scenario. While submitting, we must always bear in mind that we are not submitting our opinions, we are submitting the truth. Now, there will always be fire to that truth, and that would come for itself. Now, because our role of the professionals is very limited, I'm not going into the other detailed intricacies of a legal reasoning and other issues, because if there is a complexity, we also understand that there requires a senior counsel mostly. But briefing them is also an important task that we must all bear in mind, and we must be very capable of doing it, because ultimately they represent us, and they must not be surprised by any fact from an adversary, so that it would put us, or which would make our case bad, or a winning case lose. So this is a very short presentation that I've prepared now. I think we can discuss so that we can also address other issues which may my fellow professionals think that these are the things that we need to explore, or we need to have a dialectic conversation so that we get a more insights of what happens. So, ma'am, I request members to please initiate any dialogue or have any questions on these things, or any fundamental things that we must bear in our mind while we represent before the courts. And the important thing I also wanted to mention is that I think most of our professionals are aware that there is there's a circular very long back regarding a dress code, that what we need to, or how we must conduct ourselves with respect to the dress code while appearing before the NCLTs and NCLATs. That they have adopted, that whatever our parent members or our parent professional organization has fixed. I think for company secretaries, it's a blue suit that they're required to wear, or if it is an advocate, a black coat, that what our bar council has mandated us, or the bar council rules prescribe. So that way we are clear. And one thing I will just add to what already I have submitted, that most of the cases, or the most of our appearances, are generally confined to the NCLTs, adjudicating authorities, where we have the first-hand experience of appearing and representing. Sometimes we might have an opportunity, or sometimes we are required by the court to appear in NCLATs. Now, there would be a subtle difference between NCLTs and NCLATs, but the only matter that NCLTs being a court of first instance, that they're aware of the matter from the beginning, from its inception, either it being it a 7, 9, or a 10, whatever the petition may be. From the beginning, they are aware. So we must understand these subtleties while presenting our case. Where in an appellate tribunal, it goes on an issue basis, an impugned order, a resolution plan, or a particular directions or a particular decision of a tribunal on an issue of an EMD, or these are confined to the issues where we must give detail to the facts so that a considerate view is taken by the appellate tribunal. This one thing I wanted to mention. Ma'am, now I'm open for any questions or any discussion on this. Or like if I want to elaborate on any specific topic or a specific issue with regard to the appearances in the courts or a courtroom essentials. Yes.
Yeah, thank you, Ravi. Thank you for sharing your insightful and valuable experiences, and also uh, to start your case with a power statement, and also place all the facts and be honest, truthful, and while presenting your case, and finish powerfully. So this is the statement, and with this, I also request members who are advocates and insolvency professionals practicing across various NCLTs, NCLATs, or Supreme Court, since this forum is insolvency professionals, or otherwise with any other courts where the IPs or the advocates have experience, they can share. And also, if you have any questions on the topic, our speaker will be able to elaborate further. So any queries or clarifications, or you want speaker to elaborate on anything, or as an IP, what is your experience in court, you can share.
I see a hand raise.
Am I audible?
Yes,
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 sir,
sir.
you are audible,
Yes, sir.
sir.
Yes, sir. You're audible.
Good evening, good evening. Mr. Ravi, you have explained it so nicely. I know I'm missing sometimes because I became IP only in the month of August and I got only a year to work. 15th August, I'll be retiring from that. So I actually wanted to enjoy these moments also. But you have explained it so well. Now, even if I talk something, it is all, what I have learned or heard from people like you. Excellent. You have explained it so well that your extended hand for the NCLT and all the codes, you can say. Excellently, you have explained it. Hats off to you and your way of expression and your experience, everything. IPNet is doing wonderful. Heads off to IPNet also for making.
Thank you so much, sir. Thank you so much for your kind words, sir. Thank you. Thank you.
So anything you want to add, Hari Prasad sir, on this? Sir is also practicing advocate.
No, madam. He made it very simple, lucid, and crisp. So we did not ask anything. The very important thing, practical aspects, which the advocates and IPs are. It's nice. No specific question.
One thing I should add about Hariprasad sir, because I see quite often in the courtroom, sir comes and sir precisely knows when to speak, when not to speak, and when to stop speaking, which is very important for us as well as the professionals when we are dealing matters before NCLTs or NCLATs. That would decide the fate of our case, positively or negatively.
Yeah. Thank you.
Yes, sir.
So, Ravi, can you just throw some facts on what is the court craft in Bhushan Steel or whatever? Few facts.
Ma'am, to be very honest, if we started to speak on Bhushan Steels or any big matters, now the lead there would be taken always by senior counsels, where they were stalwarts already in the profession, So a stalwart to a stalwart, a senior member of the bar representing the cases on either sides, for either for the JSW or for the resolution professional or for the monitoring committee or for the lenders for that matter. And the judges are the senior most judges. In fact, I think Mr. Neeraj Kaul, senior counsel, who's appearing for JSW, his brother is a retired judge of Supreme Court. So Sanjay Kaul, this is Justice Sanjay Kaul. So I think if it goes to that point of a Supreme Court or appellate tribunals, there the situation entirely changes. Then that becomes beyond the domain of the IPs, I may say, because the entirely lawyers would take over the senior counsels. But there also there is an important role for our professionals to play. That for them, we are instrumental in facilitating them to submit that vehemently or oppose vehemently. We must tell immediately if we as a professionals, if we are present in the courtroom, if something or some suggestion put to the bench, because most of these are commercial laws. A commercial law, deciding on a commercial law will have a serious implication on the stakeholders. Either ways, it would be having a good implication or a bad implication, or sometimes an implication may be good, but it would be a risk taking, or taking a more haircut, or taking something very contrast to their own interest. If we are present that day in the courtroom immediately to assist the senior counsel, then immediately at that point, the idea which has popped up in judge's mind would be taken away by counter submission, saying that how that would affect the stakeholder from all angles. So that way, if we are thinking, if we are seeing, if we want to elaborate on what role we play as an insolvency professionals in litigation before the appellate tribunals or Supreme Court, is that my humble request is that at all times we must not miss that opportunity to be present in the court and assist the senior counsel, because we are the fact masters. Like, we know what is happening from day one. We know some facts which they also do not know, because they will purely go by the brief, which were prepared by lawyers again. Or if some intricate details needs to be required, because even that's in fact that's the wisdom of the senior counsels. What they do is we juniors quite often would be very anxious to tell too much. That we would pull their robes, saying that, sir, please say this, we are missing out on this. They would say, no, wait, not required. The judge is on our side. The judge is swinging to us. So like, we need not tell. But that giving information is our responsibility. That we must not commit any error in doing that. Now, it is the wisdom of the senior counsel that, again, as I said, that Hari Prasad Garu, with his long experience in his own industry and then coming to, he knows when to speak, where to speak, when to stop, and where not to speak. So this purely comes from an experience point of view, that the hard experiences that we face for speaking something which we ought not to be spoke, or something. Very, very interestingly, if I may say, recently an NCLAT in our matter, where, ma'am, you were also there, where without going into the detailings and names of the things, the respondent counsel was anxious and was very prompt in filing a counter even before issuing notice. So judge, on a very lighter tone, this all happened on a very lighter tone, nothing on record. He said that you must always know when to file counter and when not to file counter. Now that you have filed counter, then I would be inclined to give an interim order, because your stand is already there. sometimes he was just giving. He's a very very great the judicial member with his with his wisdom and his vast experiences. He suggested us that UN councils must always know when to file counters and when to take time to file counters when in an adverse situation. And he was also telling you also know when once interim order is granted, what will happen. So these things are very subtle things, but though very small gestures, maybe sometimes client compels us to file counters, then it is upon our experience and wisdom that we must advise them properly that when to take time, when to file within time, and when not to file at all. So these are certain intricate details, man.
So can you just share us few suggestions what we need to keep in view when we are dealing with the courts, NCLT, NCLAT or Supreme Court?
Ma'am, so basically, as per the rules and these things, we as a professionals, like an insolvency professional point of view, we are only permitted to appear in NCLTs and NCLATs. Anyway, Supreme Court is ruled out unless it is a party in person petition. The councils would represent. Now, in NCLTs and NCLATs, that we must always bear in mind that I told the earlier distinction that NCLTs are court of first instance, where they are having a precursor or a pre-notion on the case, or they themselves are aware to an extent that what is the case, what is the status. So we will have an added advantage. But in NCLAT, we must set the stage for the judge to adjudicate it, so that an effective order or an effective decision would be taken. And one thing as a professionals, because the professionals mostly have their own domain experience and very less interactions with the court or the judges. I will only tell one small thing which my seniors have told me when I started my practice, that in the entire history of the judiciary, there is not even a single instance that any judge has come down and slapped a lawyer. So don't be afraid in submitting anything. However obnoxious it is, the proposition that we may place, because our requirement would be in such a way. We would say when a liquidation matter would come, there would be tenants in the premises who are not paying rents. Now, how to sell the land or to sell the property unless I would not evict them? If I go to the tribunal, NCLT, and say that give a direction to evict, if something comes out from the judge saying that why don't you go to a civil court because this is a matter of eviction, your tenancy rights are to be decided, then we should not be afraid to say a proposition which on the face of it judge is disagreeing also. That why that is so important to me. Why this court has power. Earlier, what as I was emphasizing on, that we must communicate our idea so clearly and concisely that by the end of the hearing, the court must have a clear idea of what we are asking for. And we must assure that the court has the power to do it. And this is the best way out, that the best solution that we are offering. Or even if the adversaries come also, our reasoning must be the best one out. If having been satisfied these three, then the ultimate result would that we have already persuaded the judge and we will get an effective order. Now, getting an order or taking a position contrary to what we express is not always bad. We are also professionals. Our job, in fact, it is our duty to inform the court about the law, about the facts. Now, it is their duty to judge it. But while deliberating these things, we must always express very clearly that what are our interests and what are we seeking from them. in expressing, because what I see is this, because sometimes judges become so harsh, because and the professionals, because they do not on a day-to-day basis deal with the judges, so sometimes there will be an inhibition, natural inhibition, that should I speak at this point of time or not. But we must also not take, because having a dire urgency, we must definitely speak whatsoever, however disconcern the judges or however dissentious the judges. It is our responsibility to speak, because that is the need of the hour. But we may not trouble them for every trivial issue. Sometimes we must also let go in a greater good. If ma'am, if you may remember, in Karvi data management, we have moved the court on an unauthorized transaction by a banker. There was a dire need, even though the court generally do not sit afternoon. They were moved by the urgency that we have prayed. If that day, had we not made a mention and waited that the matter would be listed, or the judge will shout at us if we make a mention at this unlikely hour, that too because we made when they're raising before the lunch. The need of the hour was that day that we need money so that our operations would continue. They will always consider it, but we must know that is it urgent as well as important. That decision we must take, and we must also take the responsibility for outcome of it. Sometimes the judges may not concur with the urgency that we may plead. We may not press for an eviction of tenant that much as we pressed for an unauthorized transaction, because we needed money, because evening the operations would be stalled that day. But an eviction of a tenant would also wait for tomorrow or a day after. It is not a dire. That judgment we must have. That would be my suggestion. Yeah.
So Ravichandran sir or any other advocates who are also IPs want to share any experience or any queries, sir?
Ma'am, how is people's experience with the Amravati bench new technical member? Because I have managed to fight with him as an RP and advocate. I mean, I know it's not a forum where we are recording any such thing. Just some experiences. Is it me only who is feeling, or somebody would like to say, or maybe Tejaji? I'm Devrat Rana, advocate IP. So,
Yes. I know, sir. We were part of a litigation in Hyderabad.
aware of that. So after
It's
working in
universal,
this
sir.
sector for 8 years, it's not that judges should not ask us question,
Yes.
but totally irrelevant questions, and at times, we are also human being, right? We
Who is the
also
member now? Who is the member now in Amravati?
Sir Chandigarh.
Oh, Shukla ji.
Yes.
I'm from North India and I have faced them so many times.
Yes.
Faced him so many times, yes.
Now he has reached.
So congratulations to you. You are having a very good member now. and we got rid of it.
I know you got rid, sir. I don't know what to say. So 2 days
No,
back.
no,
only
actually, this is not a platform to discuss these things. Actually, I
Yeah.
feel personally.
Fair
So
enough.
They are always respected members. Actually.
Okay.
Okay.
So Shyam sir, can you share some insights for the IPs here?
I
It's
feel,
all good, ma'am. Actually, as IP insolvency professional is concerned, we are facing lots of difficulties in pursuing the matter with the authorities. Authorities, I mean to say, at our side, Noida and Greater Noida, which are land owning authorities, actually. Even lawyers are facing very large difficulties to confront with the Noida and Greater Noida. because they are not deviating from their, stand. First of all, the claims filed by them are above the, over and above the CRP period. Then they are asking for the whole claim as per the judgment of this Prabhjit Singh Soni. And now how they are coming, they are asking for the money which is occurred during the CRP period. So things are going very bad in this area actually. So if Mr. Ravi would throw some light on it.
Sir, these things I think we should bring to the notice of IBBI or the ministry, saying that there must be some synchronization of the authorities, because I remember a judgment, okay, very interesting. That is nothing related to this thing, but an interesting finding that they have given. In fact, that is a precursor to the entire IBC and the new Companies Act. It is in the Satyam's matter. Satyam Computers, the now retired judge, Supreme Court, Justice V. Ramasubramaniam, now currently is the chairperson of National Human Rights Commission. Back then, he was a judge in Telangana High Court, Hyderabad High Court. So, what happened in Satyam matter was, once it was they've disclosed that they've committed fraud, so and so, the central government has superseded the board. After supersession, they've invited for a strategic investments from third parties and all, and accordingly a bidder, Mahindra, has come and they've allotted they've taken over the company. Everything has happened. Now after everything is done, now ED enters into the picture and issues a provisional attachment notice to the Mahindra, saying that we are provisionally attaching the property as these are proceeds of crime. They filed a writ petition before the Telangana High Court. There, one line, I'll only say that, so say one line, why this becomes very important is, he says that when one agency of the government gives the company to a third party, another agency of the same government cannot take it back. When one ministry today, the Ministry of Corporate Affairs, is dealing with insolvency and has come with a progressive provisions of law and enabling the companies for rehabilitation and resolution, then certain state governments or certain local authorities must not hamper this. This is something, an issue of a public policy, that there must be, the government must take initiative or give some advices or guidelines for them or train them, so that these two would not contradict, or they would not create hurdles for a statute which was created by the government again. So
it may happen only with a change in the law, actually.
Yes.
Ravi, you are talking about old case. Recent Bhushan, still they have said it's a public law.
Yes.
So,
Yes.
Saab is saying that it is a public law. Now everything is a public law. What is personal law? I mean, other than Muslim Personal Law Board, what is public? What else is personal? Nothing.
So
I mean, yes, those issues are there.
Government must be very vital.
Also, can I take some view here, since many lawyers are here? ED attaches a property for what? Why do they attach it? They say it's a proceeds of crime, correct? It should be utilized for what? For somebody who has been wronged by the developer, correct?
True.
Now I'm a RP in one of the real estate company in Gurgaon. Now say we have 5 properties which are attached by the ED. And I have 5 or let's say 10 people who are sufferers of this because they were double allotments and 3. Should those properties not be released for benefit of these people?
Sir, there's a provision.
Otherwise, what will ED will do with that property?
No.
Take home?
There is a provision in 2016 when the IBC has come. There was also a parallel amendment to the ED. These fall into confiscation of properties, and there is another rule of restoration of properties. Now, in restoration of property rules, there is a new rule that has been inserted, that during the trial stage also a bona fide claimant may seek for restoration of property on showing the cause that he is not related to that the offense.
No, no, they are putting 2-3 conditions. One is they are not these are not related to pursuits of crime, and another is they have paid the entire amount through their bank account. If you are going to prove it, they would release it.
No, so who goes to the ED?
No, sir, not ED.
No,
There
you
is
have to
a
file a case in the PML, no?
special court. There is a special court.
Special
where-
court, yes.
Same thing. I mean,
Where-
okay. So when I
where-
said ED means obviously
Yes.
PML
No,
court, right?
no. So what will happen is, sir, there are two branches of proceedings that PMLA envisages. One is a civil in nature, which is the provisional attachment confirmation by the adjudicating authority. There is a criminal aspect to it, where a special court will take the cognizance once upon filing a charge sheet and a proceedings be initiated. That court is empowered to release this attachment. This is called restoration of property. Now, nowadays, on all the IBC matters, all the lenders are taking this stand. They're putting all the mortgage documents. They're enumerating all. If it is an immovable property, they're enumerating everything, saying that this has been mortgaged against this loan. This was given as a security. We are a public sector bank, or whatever case. Even they're giving in the cases of other institutional lenders as well. But the courts are taking a view to release the attachments. In fact, in Vijay Mallya's case, they've also released the pledge of shares, not only
Okay, Ravi sir.
properties.
Ravi sir, one small thing.
Sir.
As per Bhushan, now NCLT and NCLT doesn't have the jurisdiction to entertain these authorities. ED's
So
case.
it's under review, so hopefully.
Okay, fine, it's under review.
It's under review.
Now,
And they've given a status quo.
No, it's not being given status quo, I think.
No.
The review is okay.
Status quo until a review is heard
Yes.
on liquidation application.
Okay. Let's assume the both. Let's assume both the sides. Review is, judgment is reversed in the review, then fine. If it goes with the current situation, then what is the recourse for the RP now?
So there's
Where to approach now?
Sir, what I am of preliminary view is that when special court is empowered, it is better to go to that court and give an undertaking and get the property. Anyways, in 99% cases, these are all genuine claimants. The public sector banks are involved, the institutional lenders are involved. In certain cases, home buyers are involved. There would be no way related in most of the cases. The better jurisdiction.
Ravi, I don't think that is happening. What is happening is PMLA court says if it is under 32A, we will release it. You take it at that time when the resolution plan comes and the clean slate principle. Right now, we will not release it.
Dev sir, now that Bombay High Court order has also been stayed.
Sir, in fact, they say that, you know what happens? What's the logic they are giving? Suppose we give it back to you right now, and there is a 12A which happens. That means this property will again go back to the promoters. In that case, what will happen? All the efforts of ED will go waste. That is why they're saying we'll not release it now. We will release it at the time of 32A.
Correct.
So, I mean, their logic is fine. I understand. But what is happening is...
In fact, in my own case, sir, earlier, which I have quoted also in this thing, ED has filed a no objection because they said it is liquidation anyway. ED has filed no objection straight away because there's a bank involved, there's a loan involved. We also agree. They have filed, the SBI has filed the restoration of property, 2,000 acres. ED has filed no objection. On affidavit, we do not have any objection. This may be released. These are bona fide claimants. There are those instances as well, I'm then saying. So there is a contrary views that again depends on the assistant and deputy directors of ED.
And it's about our experiences, right? So that's what we are here to share. So fair enough. Okay.
Actually, my question is that actually I want one question. In case of liquidation, we are supposed to make an application for recovery of property from PMLA, whether NCLT or this special court.
No, sir.
Special court only.
Special court or appellate authority also is an appropriate body because day before yesterday, one of our parties were telling that one of the NBFC, they are telling that their appeal was disposed with a direction to approach the special court under 8.8, that is restoration
Okay.
of property. That such liberty is giving nowadays. Like it's a very recent this week update.
So can you, because I have received actually liquidation just started, and I have to recover from PM. There are only asset with PMLA. So I have to make an apply. The confusion is that whether to NCLT or special code that was there. So
Sir, mostly NCLTs are not entertaining this, or they're only just giving a direction saying that you have either go to the statutory authorities or a special court.
okay.
So they're not interfering unless it is a matter of a violation of moratorium.
Okay. Because
If
a
it is-
liquidation is there, so no liquidation is there, so we have to go to special code only. Then.
Special court. Unless the attachment is post initiation of CIRP or liquidation.
No, this is before the CIRP. So
No, they're not entertaining.
okay, sir. Thank you, sir. Thank you.
Ravi, there is a query in the chat box from Mr. Vikram Bhatnagar. He is asking, in a winding up case where CD has no assets, even to pay liquidation costs, we proposed that uncalled capital be called from the contributors under section 266 and 268 of Companies Act. However, court appeared unsure of the provision. How do we proceed now? So if Mr. Vikram is available, can you just...
No, is this a voluntary liquidation?
They are writing under section 266 and 268 of Companies Act.
Okay, and no, the winding up proceedings are under Companies Act 271.
Could be because
Or
this
voluntary liquidation. Because in voluntary liquidation,
winding up case, he is saying.
okay.
But it won't be voluntary because otherwise they would have made this payment. So
No. Recently in voluntary liquidation, there is an amendment. The provision has been omitted to recover the uncalled capital contribution or unpaid capital contribution. They've omitted it. Now the liquidator do not have the power to call for such or recover such money.
I'm saying it won't be voluntary, and any which way in voluntary they would have paid him some money not to go into this. So because they
No, there cannot be, sir. I myself am appearing for a for a contributory in a voluntary liquidation in Hyderabad, where I've challenged this action of liquidator. So
I'm agreeing to you what you are saying.
There are
I'm
scenarios.
agreeing. I'm only saying he's worried about the fees. So that fees would have been given any which ways, and then obviously he'll not take that decision. That's what I'm saying.
Yes. A very practical answer. Experience coming from.
Right here, sir.
True, sir. True.
So any more queries or anyone want to share your experience from the participants? So there is no query. There are no further queries also in the chat box.
What I'll do is, ma'am, I'll just share my email ID.
Okay.
If anybody has any queries,
Has any
they may
queries,
reach out to us, yes, so that we can have an academic discourse to that effect.
Yeah, you can share in the chat box.
I can only share to you, ma'am, but you may forward it further.
You can share it to me and also
Yes,
translation so that they will have all the email IDs of participants.
I've shared my email ID.
Yeah, we got it in the chat box. Yeah. So, thank you, Ravi. On behalf of IPNet, we are very grateful and thankful for your insightful session on sharing your experience with IPs as well as experience with the NCLTs and the judicial forums. And also thank Shyam sir and Dev sir for adding on to the points of Ravi. And also regarding the PMLA, we have discussed what is the current position, and thank you for clarifying on that, Ravi. Now I request Namrata to present the 1 minute. I'll just share the memento to our lead speaker.
Thank you, Suhasini ma'am. And we're just presenting the memento. By way of gratitude for today's seminar, thank you, Advocate Ravi Teja sir. It was a pleasure to hear about courtroom essentials for IPs, which is a much needed recourse for today for all IPs at large. And it is truly helpful with handling all the nitty-gritty in this matter. We appreciate all your inputs and we will follow suit to whatever has been shown to us.
Thank you.
The memento shall also be shared in hard copy to your office. So Asni ma'am will arrange the hard copy to be shared across to you.
I'm just trying to share this.
So Asni ma'am, if you can make me co-host, I'll present it. No worries.
Okay. Just a minute. No, you can share. I have given access to multiple participants to share. Namrata ma'am, you can share.
Yes.
Yeah.
Advocate Ravi Teja sir, thank you so much. I appreciate all your inputs.
Thank you.
We appreciate from the bottom of our heart. Thank you so much.
Thank you so much. Thank you.
So Asni ma'am, we'll have to get this arranged to sir's office.
Yeah, we'll share. Thank you, Namrata.
Thank you again.
Yeah. Now I request Rajiv sir to come and make an announcement about the next IPNet East webinar topic.
Thank you, Suhasini. I am Rajiv Kumar Agarwal from IPNet East. Delighted to invite you to our upcoming webinar on 7th June 2025 between 4 to 6 p.m. Topic is Insights from IBBI Disciplinary Committee Order. Chief guest is Mr. Ashish Makiza, sir. And lead speaker is Mr. Dharap Prasad, Insolvency Professional. And keynote speaker is Mr. Umesh Sahu, Insolvency Professional. Join us for an insightful session where we will explore insights from IBBI Disciplinary Order in detail. Stay tuned for registration details. We look forward to your participation. Best regards, IPNet team. Thank you.
Thank you, sir.
Thank
Now I request Ms. Pavitra Vyas to give expression of gratitude to all the speakers, participants, and the organizers.
Thank you, Suhasini. Am I audible?
Yeah, you are audible.
Good evening, everyone. It is an honor to extend vote of thanks for today's webinar. Today's event has been a good learning experience for all of us on the concept of mediation and skill set of IP. A wide concept and skill set of IP. First and foremost, I extend my heartfelt thanks to our distinguished speaker, Advocate Bandi Ravi Teja, for sharing his profound insights and practical perspectives of courtroom essentials of IPs. Thank you, Ravi, for sharing your time, wisdom, and experience. I would like to express my gratitude to our IPNet President, Mr. Ashish Makhija. Ashish, sir, your commitment and visionary leadership has made IPNet an exemplary initiative and a platform of great significance for insolvency professionals pan-India. Thank you for being a guiding light to all of us. A special note of appreciation goes to IPNet South team for successful conduct of this webinar. Your valuable insights and the smooth conduct of the webinar has greatly enhanced today's discussions. Special thanks to invaluable contribution of transition and the technical support team. Their seamless coordination and tireless effort behind the screen ensured smooth conduct of webinar. Our gratitude to all the participants who have joined us today. Your enthusiasm, active engagement, and thought-provoking contribution has truly made this event special. And last but not the least, our sincere thanks to Suhasini for taking out time for her ongoing course for ensuring the success of the webinar. Thank to all once again.